Hello, and welcome to my presentation on the Students First Act of 2000. The purpose of this act was to improve the quality of public education. However, there are several secondary purposes which we will discuss in this presentation. Primarily, the fundamental fairness and due process rewarded to employees underneath the 14th Amendment. This act replaces former arbitration process for firing and disciplining teachers, under which certified personnel decisions were subject to de novo review by independent hearing officers. Only limited evidentiary proceedings were conducted by employers. The SFA returns the primary authority to conducting personnel hearings to the employer. This has been met with some opposition as the school boards are now responsible for costs associated with this act. There are several employees covered underneath this act: teachers and classified employees. Our classified employees include those who keep our school functioning and running on a daily basis, including janitors, cafeteria staff, bus drivers, secretaries, CMPs, and maintenance workers. There are several who are not covered underneath this act as well. They are superintendents, contract principals, chief school financial officers, and temporary part-time employees. In addition, these people who have these jobs cannot attain tenure. What is protected? Gain of protection and status as a tenured teacher or a non-probationary classified employee. And it provides for certain due process rights in cases of transfers, suspension, termination, and other actions. Tenure. Both teachers and classified employees can gain tenure after 3 consecutive complete school years with the same employer. Tenure is considered to have been reached unless the employer issues written notice of terminating to the teacher on or before the last day of the teacher's 3rd consecutive and complete school year of employment. A complete year denotes a teacher hired before October 1st of the school year. This act includes discussions of non-renewals and terminations. Non-renewals are for teachers and classified personnel who will not be rehired for the next year. A written notice must be given before June 15th, otherwise he or she will be deemed reemployed. There are many grounds for termination: incompetency, insubordination, neglect of duty, immorality, failure to perform duties at a satisfactory level, and other good and just causes. However, termination can never be related to political or personal reasons. Termination. As a non-tenured classified employee, one needs to remember that a non-renewal is not the same as termination. However, a classified employee can be terminated at any time during the year with a 30-day notice before the board votes on it. There is no reason needed. However, that written notice is required. The employee has the right to submit a statement to the board explaining why he or she should not be terminated. Pay will end at 15 days after termination, and there are no appeal rights for the classified employee. Therefore, it's important that that written notice is received. Termination underneath tenured teachers is once again a written notice provided by the superintendent. A failure to request a hearing on the part of the tenured teacher can result in the board voting on the recommended termination. Written notice must be issued within 10 calendar days after the board has voted. Pay will continue 75 days after the board votes, unless it is based on immorality, abandonment, incarceration, or neglect of duty. The board will hold a full hearing 30 to 60 days after receiving the request from the tenured teacher. And again, once that notification is received 10 days after the vote, the employee can then decide to appeal to the Should a hearing be requested, it would go to a panel of 5 judges who are retired and neutral in the state of Alabama. One would be selected for hearing the case and would file with the state superintendent, and the local superintendent would be served at the same time. The local superintendent has 20 days to get records together to the hearing officer. The hearing officer is the judge who will be looking at the case. The hearing officer has 5 days to rule to either confirm or reverse the decision, but cannot decide a new cause of action. He or she must immediately let the board know of the decision. If set aside the decision of the board, the employee can be reinstated. Sometimes reassignments are given to teachers. They can be on the same campus without the ability to appeal on the part of the employee. It can be simply a change in grade, position, or the work location within the same school. This can only be done once a year. Board approval is not necessary, meaning the superintendent or the principal can merely reassign where you're going to be teaching within the same school. If the tenured teacher decides that they need to have a meeting with the board or the superintendent, they may do so prior to a hearing that would show where they're going to be reassigned to. Transfers can happen, which means that the teacher or the employee would be moved off the current school campus. They may be moved to another school within the district. It may not be on a voluntary basis, though. For a tenured teacher, they still need to hold the correct certification. If the superintendent wants to transfer a teacher, it must be done by the 20th calendar day after the beginning of school. Board approval is necessary, and the teacher may request a hearing before the board votes to move a teacher to another school. This can only be done one time per year. For a classified employee, they may be transferred if they are qualified. They will receive no reduction or loss in pay. They must receive a written notice not less than 15 calendar days before the decision is being made, and must be provided a notice 15 days after the board votes and has their decision. It is not subject to challenge or review, and once again can only be done one time per year. For classified employees, if they are transferred outside and it's not in the high school feeder pattern, then the employee will have the opportunity to appeal in the same process as termination. With regards to suspensions underneath this law, if it's less than or equal to 20 days, the superintendent issues a written notice to the employee and the board for the recommendation to suspend. It must contain the reasons why. The teacher may request a meeting via writing to discuss the suspension. If it is greater than 20 days, the superintendent once again must provide a written notice of the employee of recommendation to suspend and provide a copy to the board. The teacher may follow the same steps as in the termination process should their suspension be greater than 20 days. It is important to remember that at any time during any of these recommendations by the superintendent, that the superintendent and the board members must not be speaking with each other about the teachers. Terminations can happen immediately. For example, it can be revoked under 1623(5), which says you are guilty of immoral conduct or unbecoming or indecent behavior. A superintendent would recommend to the board to terminate the teacher. The board would vote. The superintendent would issue a written notice of the board's decision to the teacher. The decision is final and effective immediately. The teacher may not appeal this decision. If a criminal conviction is overturned, the state superintendent can reinstate the certificate upon receipt of notice of reversal. The system should then rehire the employee or place unpaid administrative leave with back pay and benefits from the termination date. Reduction in force. It must be prospective versus retrospective. It must be recommended by the superintendent. The board must vote. It must be unavoidable beyond normal attrition due to the decrease in student enrollment or shortages of revenues. Applied to similar situated employees. No advance notice to the employee is required. No hearing, notice, or appeal rights are provided. And the board must have a written RIF policy in place. Teachers may decide to resign from their position. They must provide a 30-day notice, meaning they cannot resign within 30 calendar days before the first day of the next school term for students. Any other employee may terminate at any time, but must provide a 5-day notice that's provided to the school system and the superintendent. Military request for leave of absence is given immediately under Statute 31213 of Alabama Code of 1975. You may also be given a leave of absence based on good cause, and it may be extended if the reason is valid. Underneath the leave of absence, it can be granted without impairing tenured or non-probationary status. Penalty. If found in violation of the resignation or leave of absence requirements, an employee is guilty of unprofessional conduct. This could lead to the state superintendent suspending or revoking the teacher's license.